Are we ready to rock and roll? All right, let me call the meeting back into session. Thank you very much. All right, ladies and gentlemen, let's go ahead and resume on our agenda. I believe, Mr. Ketty, could you remind us where we are?
At the K2 item, where the next item is K2A, the Taxpayer Rights Advocate Office Report.
All right, thank you.
Operational update on activities of the Taxpayer Rights Advocate's Office, including Prop 19 education, outreach, and other matters. This matter will be presented by Ms. Thompson.
Good morning, Chair Cohen and honorable members. I'm Lisa Thompson, Chief of the Taxpayer Rights Advocate, and I'm here to provide you with an update on the activities of the Taxpayer Rights Advocate Office, as well as Proposition 19 education and outreach. First, I'd like to share with you some statistics on the number of taxpayer cases that were completed by our office last month, and provide some insight on the types of those cases to keep you informed. This month, attached to the public agenda notice, is a memorandum from our office to the executive director reporting the number of completed cases last month. It is broken down by board member district, as well as within the administrative and valuation categories, and within the topic areas within each of those categories. In August 2022, we completed 18 cases. 6 were in board member Gaines's district, 4 in board member Cohen's district, 3 in board member Vasquez's district, and 5 were in board member Schaefer's district. Of the 18 cases, 3 were from the administrative category and 15 were from the valuation category. The administrative category includes topics such as creating and mailing of tax bills, refunds, penalty cancellations, defaulted taxes, access to data, special assessments, or direct levies on the property tax bill. The valuation category includes topics such as change in ownership, decline in values, appraisal methodology, exclusions, exemptions, new construction, actual enrollment of values, general property taxation, and assessment appeals. With respect to the administrative category and its 3 cases in total, 1 pertained to delinquent or defaulted taxes, 1 pertained to penalties, and 1 involved a tax payment. With respect to the valuation category and its 15 cases in total, 4 pertained to the actual enrollment of values, 7 cases pertained to exclusions from reassessment, 3 involved exemptions, and 1 case involved new construction. To provide some additional insight on the specific types of exclusion and exemption cases, I offer this further breakdown. For the 7 cases involving exclusions from reassessment, 1 pertained to the parent-child exclusion, 5 pertained to the base year value transfers for persons age 55 and over, and 1 pertained to base year value transfers for a disaster. The parent-child exclusion case fell under prior law, Proposition 58, since the transfer occurred before the February 16, 2021 effective date of Proposition 19's intergenerational transfer provisions. With respect to the 6 pertaining to base year value transfers, 2 occurred during the time of current law of Proposition 19, and 4 were under prior law. One of the cases under prior law involved an inter-county transfer from one county to another. For the 3 exemption cases, 2 pertain to historical aircraft and 1 pertained to the disabled veterans exemption. To provide additional insight on the nature of those cases that our office works on to assist taxpayers, I offer some additional information on a case our office worked on and how we help the taxpayer. An example of a case that our office helped resolve involved a taxpayer who had contacted our office because her property had been reassessed after she added her son on title and she received a supplemental tax bill. The taxpayer didn't understand why the property was reassessed and said that she had filled out all the necessary forms so the property would not be reappraised.
So what was the end result?
Well,
It was not
It
not-
was reassessed
It was
by
reassessed.
the assessor's office. So we helped her understand after analyzing why. So we look into specific reasons of why it was reassessed and help them understand why that is. So when, as part of that analysis, we talked with the taxpayer about her son and the addition on title. And at that time, she had indicated that she had owned the property for many years, and since she was getting older, she added her son on title, with the intent so they wouldn't have to they basically have to deal with probate after she passed, so it would be simpler. The taxpayer also said the assessor's office told her that since the property was not her primary residence and was a rental home, that the parent-child exclusion form, if it was filed, it still would not be granted. And basically, this was not a house that the taxpayer lived in. It was a rental property, and the son was added on title prior to Proposition 19's effective dates. So even if the taxpayer had not already used her lifetime limit of $1 million for non-residential property under Revenue and Taxation Code Section 63.1, because as of the date of the transfer, it would have been eligible for the transfer exclusion because the law changed as of February 16th, 2021. So we examined a copy of that deed that was provided to us by the assessor's office, and unfortunately, the transfer had been notarized had it been notarized 3 days earlier, the taxpayer could have claimed exclusion under Proposition 58 and RTC 63.1.
So she was 3 days short.
She was for that purpose, but because she said that the supplemental tax bill what we analyzed showed that 50% was reassessed on that, and because ultimately the quitclaim deed was silent as to how property was held, it didn't basically indicate whether the son or the mom held property and as tenants in common or in tenants, joint tenants. And basically, exclusion from reassessment when somebody is added to title occurs if the property isn't held in joint tenancy. In
If it is held in joint tenancy.
Yeah, so basically, if a mom, say a mom adds a son on
Right.
title, and she remains on title.
Right.
So this is different from passing away, obviously. So in accordance with property tax law and Rule 462.040, if a person is added to joint tenancy and that transferor, like a mom, like myself, would transfer it, if they remain on title, then that is not something that is reassessed. That is, in essence.
So the assessor made a
called it.
mistake.
No, the assessor did not make a mistake. There was no mistake involved on the assessor's office. It was properly reassessed.
Okay.
So it really was an issue with this taxpayer. But because she had indicated to us, the son and her, that they really were intended to avoid probate, that's the whole reason why they wanted to do this. We were aware, just based on our knowledge, from existing guidance from our Assessor's Handbook 5401, Change in Ownership, that our Property Tax Department publishes, that actually doesn't. And tenants in common is what would be something that you would still have to go through probate. Joint tenants is what it was. So we directed the taxpayer to guidance in our existing handbook, as well as Rule 462.04020 for tenants in common, and then Revenue and Taxation Code Section 61. So they could consider whether they wanted to rescind that prior transfer, and instead do a correction deed to specify that it really was in tenants in common. So the end result of that would be, if they chose to do that to their title, clarify that the intent was for it to be listed as tenant in common jointly, that would result in actually the property not being subject to reassessment. So that is something, for them to consider, and what they did. So
What county did this happen in?
I don't.
You don't recall?
No,
Okay.
I'm sorry, I don't.
It's
don't
okay,
recall
it's
that
okay.
county. But yeah, I mean, we have change in ownership cases that are throughout.
I know you do.
Throughout California.
This case is just interesting.
Yeah, it really was interesting because, in this case, although we're, confirming that the assessor treated them fairly according to the law, we were able to at least provide that vehicle, to indicate that, because of information that they provided to us about the probate, we were able to
And this is a rental
share.
property. This is not even the home that she lives in.
Yes.
The mother.
That's correct. Yeah. So, we don't know the circumstances with this, but we do know that's why he was
Reassessed.
added on a title to do that.
I'm sorry, real quick.
Along those lines real quick, so if, I know there's different ways you can do it, joint tenancies, there's limited partnerships, and then there's tenants in common, you mentioned. If it's joint tenancy, before the person passes away, now, it doesn't get reassessed when it's passed on to the, whoever's on the joint tenancy, if it's a son or a daughter?
As
or
long
grandchild?
as the person that's transferring it, such as the mom, that owned the property before, remains on title. Then that
Right,
is,
but up
that
until
is
death,
something.
and then upon death, she gets quick claimed off, no?
Well, I don't think it's a quick claim, but, so what would happen?
Well, or-
So at the time, but I mean, at the time, at the time of the transfer, so if it's under joint tenancy, if I was to add my son or daughter onto a title, onto a property, and I remained on title, there is no reassessment of that, say 50%, because the law says otherwise, as long as I do. But yeah, you would look at it like at the point, say I died, then they'd be looking at a reassessment consequence at that point. So when the original co-owner or transferor comes off title, then the entire property is subject to reassessment. That's under property tax law. So it would have to look at what exclusion laws were available at that time. So,
Given what we have today, if you were to put your child on
yep.
as a joint tenant, heaven forbid, a year from now, you passed away, your child would take ownership of it without a change of ownership, right?
He or she would take
Right.
ownership to the property, and the property tax law in place at that point would govern whether it's reassessed. Currently, if Prop 19 is still under law at that time, then yes, would not qualify for exclusion if it was a rental property. So that's kind of looking at it, but.
Would
Yeah,
have-
so the
could
joint,
I
I mean,
follow-
there's our property tax rules are excellent resources to look at. Property tax rule 462.020 and 040, those actually discuss joint tenancies versus tenants in common, and our agency's assessor's handbook on change in ownership also discusses kind of the differences in holding property. And so those are good resources.
Are
Right.
those the only two ways you can go, joint tenancy and tenants in common?
Well, I mean, I'm not an expert on obviously how title is held, but I mean, those are, I mean, pretty much it
The most
as an
common, I guess.
individual. I mean, if you're looking at corporations or limited partnerships or LLCs, those are different. But of
Right.
course, that would not be subject to exclusion under the parent-child exclusion. That's just property held by individuals.
Prior to Prop 19, it wasn't considered a change of ownership if you were joint tenant and the mom or dad passed away, right?
You could qualify for exclusion before Prop 19 on property. So it wasn't just principal residence property. There was also exclusion available under Revenue and Taxation Code Section 63.1. And that was for other properties, but it was up to a $1 million lifetime exclusion.
Okay.
So you could have a rental property, or you could have a commercial business property or an industrial property, that could be done, so.
Thank you very much, Mr. Gaines.
Could I ask another question?
Sure.
I'm sorry.
That's okay, and then I'll go
But
on
I-
to my next part.
I'm
This
just
is
trying to
the wonderful
underst-
benefit of actually, we're now
It's-
reached a point where we know what you're talking about.
Right.
It's a
You can
good-
follow the
You guys are,
conversation.
yeah.
It's
Go
a
ahead,
good
Senator.
example to look at, and I'm just, in this particular case, so the mom was adding the son, which would trigger reappraisal of 50%
Yes.
of the value?
Mhm.
Okay, and then what if the son was added, and that would trigger reappraisal of half of it, and then the mother dies, would the other half be reappraised upon death?
Upon her death, it would be 100% reassessed, because,
Oh, okay.
because the law is such that when an original transferor either is removed from title or passes, then, I mean, you are removed from title essentially if you
Yeah,
pass.
okay.
But that is subject to reappraisal at that point.
Yes, there's no advantage of adding a child or a grandchild to a joint tenancy. that
Yeah,
could
I
see
can't really
From a
say
tax perspective, because
what-
it's going to be it'll trigger reappraisal then, and then it'll be reappraised again upon death of the mother or grandmother or
Yeah, I mean,
grandparents.
it's a choice of people to do that, but that would save, at least putting somebody on title now would save at least, I mean, they would be on title, but you wouldn't be reassessed at that point. But at a later date, when that person comes on title, that you would be. And I guess depending on what laws were in place at that time
Okay.
of the death or when they're removed, then there might not be any
Okay.
property tax consequences, but there are currently,
Okay.
certainly, but again, people should look at not just property tax consequences, they should look at other tax consequences, like
probate's a big-
income tax.
a big deal,
Well,
too.
income tax purposes is another reason, but.
Yeah, the cost of probate is another aspect, but also in terms of, well, let's see, I had another question, darn it, and I can't remember right
Yeah.
now, but
It's not, I
it's
was just going to mention that
complicated,
it's not
isn't
my
it?
area,
Yeah.
but with passing on property, I mean, the disadvantage for income tax purposes by adding somebody on title now is that when you die, then you don't get the step up in basis for income tax purposes. So
Oh,
that's
okay.
what I understand other people are looking at and considering when having transfers, to their children before they die.
yeah, in this particular case, though, they were able to reverse it with no adverse effect?
They have not, as far as I know, they have not reversed it yet. We just talked with them about it.
Yeah.
It's their choice. So I did extend the offer to them is once, if they do decide to go through and do a deed correction or a rescission, excuse me, to indicate that it was in tenants, not in tenants in commons, it was actually joint tenants, then they could contact me after reaching out to the assessor's office with the deed information, and we could see, if that could be removed. Because in this case, so the deed was silent. It didn't say anything. It just said, whatever, Mrs. Smith adds, John,
Okay.
you
Didn't
know,
say
and
how.
they're together. It didn't say
Say how.
as joint tenants,
Yes.
or it didn't say as tenants in common.
Okay.
And so, under a different area of law, I believe it's civil code, basically says, if it doesn't expressly state it's in joint tenants, then it's considered to not be.
Okay, so
And
that's
so-
why there's the flexibility after the fact.
Because,
Yeah.
and because, again, they indicated that to me, to be
Yes.
why,
Okay.
the intent of it was to not, to avoid probate. And we said, well, you don't avoid probate the way you did it. And
Yeah.
so you might, want to look into that. And so they can choose to take that information. If they want to pursue it with an attorney, then they can do that. And they have our contact information, and I did extend that to them.
That's
and
great.
I'm
Thank
happy
you.
to help them later if we need to.
Thank you.
Okay, if there's no questions, I can go on to the next item. Okay, so the next item I wanted to report on to the members is on work completed for taxpayers that submitted public comments at the Taxpayer Bill of Rights hearing held as part of the August 30th, 2022 board meeting. One taxpayer, Mr. David Frankville, submitted a public comment concerning Proposition 13 and what he felt was the erosion of protections given to homeowners, and being upsetting that people can't afford to pay their property taxes with their fixed retirement income. The TRA office, during its remarks, explained that Proposition 13 was passed by the voters in 1978 and continues today with protections limiting the property tax rate to 1%, plus voter-approved bonded indebtedness, with increases in assessed value specifically to the factored base year value to 2%, unless a change in ownership or new construction occurs. I also indicated that if he finds he is unable to pay property taxes, then he may wish to look into the property tax postponement program offered by the State Controller's Office. During the meeting, Chair Cohen asked that the TRA office could reach out to him to provide a direct contact in the State Controller's Office, and asked that we coordinate with Deputy Controller Eppolite for a contact person rather than only giving public contact information from the Controller's website. After the meeting, we provided information to Mr. Frankville about Proposition 13, the limitations of the maximum 2% increases a year, and also about the requirement that the assessor assess a property at the lower of its factored base year value or market value each year. We provided information about the property tax postponement program, providing links to the State Controller's Office website that contains comprehensive information about the program and how to apply for it. Additionally, we provided the name and phone number of a person in the State Controller's Office that he could call and speak personally with about the program. We completed work on another public comment submission from the Bill of Rights hearing from a concerned tax agent who chose to remain anonymous. The comment concerned appeals in Riverside County and indicated that they weren't allowing public access to property tax assessment appeals hearings. And also that although the law states hearings must be made public, the clerk of the Assessment Appeals Board refuses to allow access. The comment indicated that the Assessment Appeals Board cited COVID concerns. However, at the hearing, the tax agent attended, not everyone was wearing a mask, and the requester asked that we could make sure the public access is permitted to the hearing as required. As part of my remarks at the meeting, I indicated that our agency's role in the assessment appeals is to prescribe property tax rules and issue instructional documents to assist appeals board in the performance of their duties, and individual counties have their own rules or actual appeal proceedings. I further indicated that our office reviewed our agency's publication on assessment appeals, and on page 96, it discussed hearings being open to the public and addresses the requirements of the Revenue and Taxation Code Section 1605.4 and Property Tax Rule 313. I explained that the statutory and regulatory provisions require appeals boards hearing and officer hearings must be open, accessible, and audible to the public, but when a portion of the hearing involves evidence regarding trade secrets, that portion of the hearing may be closed to the public. At the meeting, I also explained that after receiving public comment, we reached out to our legal department to ask for information concerning a local appeals board authority to not allow the public to access county appeals hearings in person for COVID concerns. They advised us that the state was under emergency proclamation by the governor due to COVID pandemic, and the actions of the local government and local health departments may be involved. And they indicated that we should inquire with the county and local appeals board to explore their reasoning and authority to close the meetings. As part of my closing remarks, I indicated that the TRA office would coordinate with the county on what the taxpayer indicated to be closed to the public, and the time period for which meetings were closed to the public, to see if it was in effect during the time the governor's order, and if it has since changed since those governor orders stopped. So after the meeting, we reached out to the assessor's office to ask about their experience at the Assessment Appeals Board, and they indicated that generally its appraisers go into the hearing room to testify when it's their turn, and that there are less chairs than before COVID around the perimeter of the room, presumably for social distancing reasons. They also said the appeals board may have COVID concerns due to the size of the room, and it wasn't very big. The TRA office then contacted the clerk of the board to ask about the county's policy on public access to county appeals board hearings. According to the clerk's office, hearings were closed during March 2020 due to COVID and reopened for in-person hearings in July 2021. Before July 2021, hearings were held via Zoom. Following the beginning of COVID, once they learned how to set up virtual hearings, they indicated that while hearings were held virtually, only AAB members and the clerk were allowed in the hearing room. As to in-person hearings that opened up in July 2021, the clerk indicated that although hearings were open to the public since July 2021, due to their county's ongoing concern with spreading of COVID, the small hearing room and the AAB members are seniors over age 60. If a person isn't connected with the case being heard, the clerk of the board prefers the person contact them to request attendance at the hearing, and they will try to accommodate them, but the 6-foot social distancing would likely not be possible. They indicated that persons showing up on the hearing day without an appointment may be allowed into the hearing room, provided there is room, depending on the total persons already attending. The clerk also advised the assessor's office that the assessor's office only brings 1 to 2 staff to present evidence, as opposed to the past, when they had more staff attending to listening to the hearings. At this time, persons awaiting their turn to present their own cases are asked to wait outside the hearing room until it is their turn. The county clerk of the board also advised it that the policy is meant to protect the public as well as employees, and they're open to suggestions how they could operate hearings in a safe environment for all, while still being within the Ralph Brown Act, meetings open to the public. Additionally, the county clerk of the board advised us that if people wish to be informed about the hearing, they can purchase an audio recording of the entire day's hearing, and it is $5 to make a copy of that tape. So based on our office's review, it seems that the appeals board in Riverside County are available to the public, since a person can request to attend a hearing even if they are not presenting or they are not involved with that case. And people are allowed to be in the hearing room subject to capacity restrictions. And also, since anyone can obtain an audio recording of those hearings. The next item I wanted to report on is to keep the members informed is on work associated with Proposition 19 education and outreach. As I indicated in my presentation at the July board meeting, in June, our office completed work on 6 information sheets, and they were published to help taxpayers understand property tax laws and exclusions available to them. Thereafter, I had sent a letter to the California Assessors Association President Leslie Morgan, advising her of the issuance of those information sheets, where they can be accessed on our website, and asked that she share that information with California assessors as well as the CAA affiliates at that August conference that was held. Since my last update, the TRA office has completed work on a new information sheet for base year value transfers for disabled persons under Proposition 19, as well as revised the existing publication to identify them as applicable to transfers prior to April 1st, 2021. These information sheets were posted to our website last week. And at future board meetings, I will provide further updates on the activities of the TRA office to keep you informed. I'm available for any further questions if you have them.
All right, thank you. Just to be clear, this information that you were reporting on has happened in this year, in 2022?
Yes.
The report, right. There was,
so I started
one of
with-
my colleagues had a question
Oh, I'm sorry. Okay.
as to the report that you were making, was it this year or last year? And I just wanted to say for clarification and for the record that you were reporting on conversations and cases that are happening in 2022.
Yeah, yeah, the cases that I'm referring to, so the beginning portion, when I talk about completed cases, it's for the prior month that we completed work on. But as far as the second item, it was items that we actually completed work on largely in September for the 2 items following the Bill of Rights hearing, because the Bill of Rights hearing was on August 30th.
Of 2021.
Of 2022.
August. Oh, yes, you're right, last month.
Yeah,
You're right. I'm
so
sorry.
yeah, so yeah, so
sorry,
for
yes.
so I wanted to do that as a separate item because I felt that was important. So the members were advised that we did take care of those 2 items. So in the upcoming months, I will be also including those. So as we finish cases that were brought to us or issues that were brought at the Bill of Rights hearing, then I'll report on that, kind of on a separate item. So in that respect, most of them would be done probably during the current month.
Great, thank you very much, thank you. Thank
You're
you.
welcome. Thank you.
Questions on this side, am I right, Mr. Eppolite? Is that a yes? You have a question?
Yes.
Go for it.
Ms. Thompson, on the information sheets that are being posted, what was the review process on those documents?
Well, so the TRA office prepares them, and then they're circulated through an internal review process. So our legal staff looks at it, property tax department looks at it as well. So, and then of course our executive director looks at that.
Okay.
So
Correct. Thank you.
You're welcome. And our communications officer does also. Thank you, Peter, for
Mr. Vasquez?
helping with those.
Just a quick question. First of all, thank you for the report and all the detail, but I've noticed on the Prop 19 information sheets your office has prepared are reachable, with the link under the taxpayer's education. And within that menu, the options are from the main TRA web page, but they don't seem to appear on the Prop 19 link or the web page.
Yeah, so actually, I worked with the communications officer earlier. We were waiting until the base year value transfer for disabled persons was added last week, so posted. And so earlier, I think Monday, this is Tuesday, so yesterday, it posted. So another link was created following last week. So it's actually added under the additional resources area of the Prop 19. So you can
So you can
get
get
to
it through
that.
the Prop- okay.
Yeah, I don't, I think it's the third, bulleted item, but it's there now, so it actually links you, so, yeah, thank you for that. So we'll
Appreciate
get, we want to expose as many taxpayers to it as possible, so.
Thank you.
Thank you. Any questions on my left? Yes, Mr. Schaefer?
Thank you for your report, Ms. Thompson. It comes to mind that you are more informed on all these statutes than any of us are because you work with them all the time and do a lot of good for people. And it also occurs to me that there may be a statute that if you wish it were a little bit different, you could do so much more to help the taxpayer, but you're stuck with the statute. In those cases, I would like very much to have you write a little memo on proposing a modification in the statute by the legislature that, if it were done, would enable you to do so much more for the taxpayers that are coming to you for help. I guess you would make that to our executive director, and she would share it with us. And each of us have friends in the legislature, and we have our own legislator, like mine from Southern California. I would call upon my legislators to say, look what Ms. Lisa has found up here, and how if we tinkered with it a little bit, we could do so much more as a BOE, and, we could end up with some happiness and benefit to a lot of taxpayers that maybe was started with an idea from you. I just want to be able to do more to help the taxpayers, and I am impressed with the stuff you run across. And maybe you should be up here. You could do a lot of stuff.
I think if we saw, something, other than, we implement the law. Our agency implements the law, and our office ensures taxpayers are treated fairly according to the law. If we saw something that was maybe hindering the ability for a taxpayer to maybe comply with something, then that might be something that we would, identify internally and through our, legislative process. But in this case, for change in ownership laws, just like, the reassessment consequences for rental properties under Prop 19, the California voters voted, and so they voted that in. So we're happy to help taxpayers, ensure they were treated fairly according to the assessor's office, but it's not something maybe
No, you
we
do a
might
very good job.
change. Thank you.
Thank
Well, I'm fortunate. I have a really great staff. I also have a property tax background, so I think that helps quite a bit.
Agreed.
Thank you, Chair Cohen. If I can
hold on.
interrupt really quickly, I just wanted to remind the board that for those kinds of directions, the board as a group should have a consensus and direct the executive director to direct staff to do any ideas. But all good ideas to be discussed. Thank you.
Mr. Gaines, did you have anything? No? All right.
Ms. Thompson, did you say the information sheet on Prop 19 has been issued or is still forthcoming?
No, well, okay, so there's there's the Proposition 19 fact sheet, but there's also information sheets that the Taxpayer Rights Advocate Office, so I don't know if you're looking at the Prop 19 tab, are you going toward
I'm on the
Mr.
Taxpayer Rights
Vasquez's?
Advocate Office.
Okay, so like if
information
you're,
sheet page.
okay, so you've picked taxpayer education and you're there. So if you go to the very bottom of the website and pick Taxpayer Rights Advocate Office, one of the choices, it's taxpayer education. And then if you click taxpayer education, then you get to the page where you'll see all of our information sheets on all topics. They all happen, to pertain to areas that were affected by Proposition 19 now.
Okay.
Yeah, and what Member Vasquez was referring to, if you go to the very top of the website and do the Proposition 19 page, if you do that, there's several tabs within because we have comprehensive information about Proposition 19. One of those was additional resources.
But I thought you had said that there was an information sheet specific to Prop 19.
Fact sheet. Yeah, it's
Okay,
it's
fact
a
sheet.
Proposition 9 fact sheet.
Okay.
Although so it's not one of the Taxpayer Rights Advocate Office information sheets, actually kind of produced by the agency, but Peter Kim, the communications officer,
Right.
and I, as a Taxpayer Rights Advocate, essentially did that. So,
Okay.
yeah, so it's not under the TRA, but we're
Right.
actually contemplating somehow linking that into that. So he and I are exploring that now to somehow maybe get it back to the Prop 19 page.
Okay. Thank you.
So,
Thank you. All right. Thank you.
thank you.
We're going to go to public comment. See
Yes.
what's-
AT&T moderator, please let us know if there's anyone on the line who would like to make a public comment regarding this matter.
Thank you. If you would like to make a public comment on this matter, please press 1 followed by 0. 1 followed by 0 at this time. And Madam Chair, nobody's queuing up.
I appreciate that. Thank you very much. We appreciate your work. Very important, Ms. Thompson.
Thank you so much.
Mayor, very, very impressive. Thank you. Ms. Cicchetti, who do we have next?
Well, normally we'd go to our next item, but it is 12:30, and I
Oh.
wasn't so sure if you wanted to break for lunch right now or to take the next item up.
Let's break for lunch. Let's break for lunch. Ms. Lumsden, we'll hear from you right after lunch, okay? Ms. Cicchetti, could you let us know how long do we have for lunch?
45 minutes?
45 minutes. Okay, so we will reconvene at 1:15. Thank you.
Thank you. them, of course.
All right. All right, good afternoon, ladies and gentlemen. Let's reconvene. It is 1:19, Tuesday, September 27th. Ms. Cicchetti, could you please?
The next item on the board agenda is K4A, Property Tax Deputy Director's Report, Operational Updates. Report on the status of pending and upcoming projects, activities, and departmental issues, including Proposition 19 implementation actions and guidance, letters to the assessors, appraisal, training, and certification, assessment practice surveys, and the state assessed property. These items will be presented by Mr. Young and his team.
Thank you, Mary.
Hi, Mr. Young.
Yes. Good afternoon, Chair Cohen, honorable members of the board. For the record, my name is David Young, and I'm the Deputy Director of the Property Tax Department. So along with my usual report on Prop 19 implementation, I have 2 additional reports to give after that. After my 3 reports, I will turn it over to Ms. Lumsden, who will have the next 3 sub-items, and then to Ms. Cruz for SAPD and 1 sub-item there. So with your okay, I'll start with the Prop 19 implementation.
Yes.
Okay. Staff continues to monitor the progress of property tax rules 462.520, the intergenerational transfer property tax rule, and 462.540, which is the base year transfers through the promulgating process. As of last week, it has been turned into the Office of Administrative Law for their review. Pending their review, it will then be posted on their website. That will begin the 45-day public comment period. Our goal is to have it before the board in November for public comment. Of course, staff continues to answer inquiries from taxpayers and other stakeholders as part of our daily routine in implementing Prop 19. And staff is also continuing their process in reviewing our website dedicated, our webpage dedicated to Prop 19. So work continues there. And if I may actually loop back onto an issue brought up by Board Member Gaines, on Prop 19, the board staff has already worked on implementing our technology component of it. So there is a requirement that we track the base year transfers. Each person now, instead of allowing 1 base year transfer, they're allowed 3. So we have since expanded our system, and it's already live, and we're already tracking that, so we're in good shape. So I just wanted to loop back and answer that for you. The next item I wanted to bring up to give you an update on is our welfare exemption process improvement project. As you will recall, staff has been presenting on that for about a year. That was started in direct response to inquiries about our processing of applications for the welfare exemption, and specifically for low-income housing. There was some issue as to, are we doing it, are we handling it quickly, how are we turning things around? So we started on a project, on a process improvement project. We took a look at the items it would take for us to actually accept, review, and approve these applications. Some of the steps we took were we re-examined the actual application. We streamlined that. We made sure that we were asking for the information that we actually need in order to make a determination, nothing more, nothing less. We've also clarified our instructions in there to make it a little simpler to understand, and we've added information to our website to as extra guidance for applicants when filling that out. And on our end, we took a look at our internal processes and what we did in order to review it. We tried to streamline that, and where we can, we did concurrent reviews, and we try to look for bottlenecks and to solve that. So we've been at it for about a year, and now I have enough data points where I can actually come and report back to you. So I'm very happy to report that our efforts are actually starting to pay off. So as of this year, as of the end of August, we've already approved a combined 877 OCCs and SCCs, organizational clearance certificates, and the supplemental clearance certificates. For affordable housing, they actually need both. So we've already approved 877 for, as of August of 2022. For all of last year of 2021, we approved 833. So we're only partway through the year. We have 4 more months to go, and we're already on track. We've already beat our last year's record, and we're on track to do even more. So initial results are very encouraging, and I think a lot of that is due to the revamp of our application. It's the real benefit to that is that it's easier for folks to fill out, and when we get our applications, it's more complete, and it has the information we actually need. So there's less of that contacting the applicants, getting additional information, waiting for them to submit, us looking at it again and again, having to handle the application multiple times. So that has gone a long way in improving that process.
Thank you.
Okay. And then the last item I want to give you a little bit of an update on is the vessel's valuation factors. So annually, the board publishes these vessel valuation factors, and they're meant to assist county assessors in the assessment of vessels. And vessels include powerboats, watercraft, sailboats, and whatnot. So every year, the staff collects information and data during the year to figure out if you bought one of these types of vessels, what happens to their value at the next lien date. We collect that data, we analyze it, and we publish these factors to help the assessors come up with a fair market value. And it's usually published right around the beginning of the year so they can use it for the lien date. So for 2022, the factors were published in the LTA. It's LTA 2022/003. And those factors show a general increase in the value of these vessels that were purchased in 2021. So for next year's lien date, as of January 1, 2022, in general, they've gone up in value. And that is to reflect that over the course of 2021, because of the higher demand for these types of leisure property, the demand has gone up and the supply has gone down, supply chain issues, workforce issues. So it's, in classical economics, supply and demand, it shifted. So it resulted in a higher value. So when applied to this year's assessment, a lot of vessel owners actually got a higher tax bill than last year. So you may or may not have heard some of this in your respective districts. So as always, if there are any questions about this type of assessment, the first stop is always with the county assessors. They can call their county assessors and ask about the assessment. If there's no resolution there, as with any other assessment, their recourse is to, of course, go to assessment appeals. And the appeals information and deadlines are actually given to owners of these types of crafts, either with their notice of assessment or with their tax bill. So one or the other will have that type of information on there. So it's just, if you have heard of such issues in your county, that is what we do, and that's probably why it's been happening. It's because overall vessels have gone up in price in the last year, 2021.
Okay.
It concludes my 3 issues for the property tax department. I'm available to answer any questions you may have.
I don't have any questions. Mr. Vasquez?
First of all, thank you for that report, and and then it was refreshing to hear how some of the things you're doing now has really helped in terms of streamlining the process, especially given the numbers from last year.
Right.
And I was just wondering, building on that success, have we ever tried, or have you ever tried maybe producing some kind of a video that can kind of expedite so you don't waste so much of your staff time on it, and hopefully beef up the numbers? Because it looks like you're obviously going to do better than last year.
Yeah.
But there's still a lot of folks that they get caught up in this waiting period.
Right, right. It's an issue of resources and time.
know.
I mean, I think it's a great idea. I will have to look into whether we have the resource and the ability to produce that. I think it would be helpful.
Okay.
All right, Mr. Eppolite?
Yes, I just wanted to chime in as well and applaud staff for its efforts on exemption claims and help expedite housing efforts throughout the state, so thank you.
Thank you. Thank you, Deputy Controller Eppolite.
Thank you. Anyone on my left? Mr. Gaines?
Yeah, thank you
Yes.
very much. Appreciate your presentation, Mr. Young. And I wanted to make sure that you brought up this issue on vessels, on watercraft, because I've gotten questions from my constituents as to why, their property tax on their watercraft has gone up. So I just thought in terms of transparency, it's good to bring this forward. And my hope is that we could do this on an annual basis in the future, because it's pretty unusual to have the value of your boat actually go up year over year, because it's typically depreciating and that taxation is declining. And so I just think that it's, to the degree that we can make our constituents aware of it, and then what they need to do in the event that they want to challenge the valuation. I think in many of our counties, there's, I think, a November 30th deadline is what you had discussed earlier with me,
Yes.
David. And so I just wanted to make sure our constituents are aware that if you're not happy with the valuation, you have an ability to appeal that through your county assessor, but also understand the market's changed. And just as you described, there's been, limited supply and a lot of demand for watercraft, and as a result, prices have been going up. So thanks for bringing that forward.
Of course.
I've got, I don't have huge amounts of watercraft, but I've got some big lakes like Shasta Lake and Lake Tahoe, and people own boats and they're wondering why those taxes are going up. So,
Okay.
Thank you.
Thank you.
Okay, thank you very much. Thank you.
Okay. Then I will turn it over to Ms. Lumsden for the next presentation on letters to assessors.
Thank you, Mr. Young. Good afternoon, Chair Cohen and honorable board members. I'm Patty Lumsden, and I'm the Chief of the County Assessed Properties Division. And this afternoon, I'm going to be giving you a brief report on letters to assessors. And attached to the agenda again this month is a memo on letters to assessors, which provides a list of the LTAs that have been issued since our last board meeting, and in addition, provides a link to all the letters to assessors that have been issued to date. As of the date of the attached memo, BOE staff have issued a total of 41 LTAs for calendar year 2022, and 3 of those LTAs have been issued since our last board meeting. Those 3 LTAs are summarized as follows. An LTA we issued was on the Assessment Practices Survey Report for Sacramento County. We also issued an LTA providing statistical data collected by BOE staff from county assessors regarding community land trust housing for the January 1, 2021 lien date, as required under Senate Bill 196. As you may remember, Senate Bill 196, which became effective as of January 1, 2020 lien date, added Section 214.18 to the Revenue and Taxation Code to allow a CLT, which is a community land trust, to file a claim for the welfare exemption if certain conditions were met. In addition, Uncodified language in SB 196 required the BOE to annually collect data to quantify the amount of the assessed value exempted and the number of owner-occupied dwelling units or rental units, or both, created by CLTs that were granted this exemption. Finally, we issued an LTA which provides the annual per acre value of California irrigated cropland for lien date 2023 to be used by county assessors when valuing enforceably restricted land subject to an urban agricultural incentive zone contract as provided under Revenue and Taxation Code Section 422.7. That will conclude my report on letters to assessors, and I'm happy to answer any questions you may have.
Mr. Vasquez has a question.
Certainly.
Just a quick one on the LTAs. Is your department looking to possibly put out an LTA regarding the streamlining of the welfare exemption process?
At this time, we were not planning on doing that. Is there something more specific? And did you mean in terms of talking about the expansions that we've made, or was this something?
Pretty much along those lines, and what I think Mr. Young mentioned earlier in terms of the streamlining, how you've obviously helped in expediting this thing, and I was wondering if it would help some other counties to know that.
It's something we can look into.
Appreciate it.
Certainly.
That's all.
Thank you. That's it.
Okay. Okay, the next presentation will also be by Ms. Lumsden, and it will be appraiser training and certification.
Thank you again, Mr. Young. Again, I'm Patty Lumsden. I'm the Chief of the County Assessed Properties Division. And now I will be giving you a brief report on the BOE's appraisal training and certification program. Posted to our website is the appraiser training schedule for the 22-23 fiscal year, where we have scheduled 33 classes covering 8 different courses. And as you may remember, last fiscal year, we were only able to schedule a total of 23 classes and convert only 5 of our most requested courses into a virtual teaching format. This fiscal year, we have scheduled an additional 10 classes and an additional 3 different courses than what we were able to offer last fiscal year. In addition, we're offering both in-person conducted classes as well as virtually conducted classes. So for the 22-23 fiscal year, we have completed 6 classes, and 2 of those classes were completed since our last board meeting. And those 2 classes were Course 56, which is Advanced Sales Comparison and Income Capitalization Approaches, which was taught in person by BOE staff in San Diego, which of course is in San Diego County. And then we also taught Course 52, which is Valuation of Restricted Lands, and it was taught virtually by BOE staff through Microsoft Office Teams. And that will conclude my report on training and certification, and I'm happy to answer any questions you may have.
Okay, let's see, am I right? Any questions? I think it's pretty straightforward. Any
Okay.
questions? No? Yeah, thank you.
Thank you.
Okay. And our last sub-item for Ms. Lumsden will be assessment practices surveys.
Okay.
Thank you. Again, I'm Patty Lumsden, Chief of the County Assessed Properties Division, and now I will be giving you a brief report on our assessment practices surveys. For calendar year 2022, we have issued a total of 8 assessment practices survey reports via letters to assessors for the following counties: Santa Barbara County in District 2, Alameda County in District 2, Sierra County in District 1, Stanislaus County in District 1, Amador County in District 1, Inyo County in District 1, Sacramento County in District 1, and most recently, Los Angeles County in District 3. Los Angeles County you won't see on the letters to assessor memo because it was posted after the date of the memo, but that did get posted just last week. In addition to these 8 counties, we actively are working on completing surveys and/or samples for 10 other counties, 4 of which are in District 1, 4 in District 2, and 2 in District 4. Now, these surveys and samples, of course, are in various stages of production, and once they're completed, we provide a copy of the report to each of the board members and their office for preview before it is issued and posted to our website through an LTA. BOE staff continue working with their new hybrid plan of collecting some data remotely and some in person. We've started traveling again, as I mentioned last month, depending on each assessor's ability to accommodate our hybrid plan. So we work with each assessor's office prior to going to their office to see what will work best for them based upon their staffing and, of course, their computer systems. So we will continue to monitor this new process and make adjustments as needed, and that will conclude my report on assessment practices surveys. And I'm available to answer any questions you might have.
Yes, Mr. Vasquez?
Just one quick one, kind of going back to your first part of your presentation. I noticed you, you mentioned that you're doing a combination of in-person versus virtual classes. And I'm looking at the schedule for 2023. How do you determine which ones are which?
So we tried to do a variety. We tried to do kind of half and half of each subject.
the
So I
subject
call it
matter.
a course. And so, for example, if we're teaching 6 course 3s, we're trying to do 3 of them in person and 3 of them virtually. So that gives the assessor and their staff the option
The options.
of attending in person or virtually, whichever ends up working best for them.
And now to your last part of your
Sure.
presentation. I was looking at, I guess in the findings in the report, especially about the Los Angeles County assessors. And the assessors, for the most part, agreed with most of the findings, but they do not concur with with the department. What happens in that case if there's a difference?
So it just depends on what those differences are. The recommendations, of course, there are recommendations, and the assessor can take them into consideration, and they review them, and they determine whether they agree. If there's a large disagreement, sometimes we agree to disagree,
Right.
and or it could be that there's a disagreement in terms of what their office is capable of doing, because sometimes could be a computer issue, or it could be staffing issue, or resources, or something that is not really something that we would need to address. But if there's something where we completely disagree with one another, typically what we have done in the past, which we have not done very often, is we will then we have the ability to then make a statement in regards to that, to the assessor's response. But we have not done that, we have not needed to do that in most cases, so.
Thank you.
Any on my left, questions? Mr. Gaines?
Yeah, if I could, thank you. On your report about the 3 new LTAs, you had mentioned per acre value of ag land. And can you maybe explain a little bit more the purpose of that?
So we annually, and keep in mind, I'm not an expert on this particular topic, so we annually issue the cropland, irrigated cropland numbers. And so we get those values just to try to make things more accessible to the assessors, because they could actually get this information as well, but we provide it to them. So Revenue and Taxation Code 422.7 requires the county assessor to value land that is enforceably restricted at a rate that is based on the average per acre value of irrigated cropland in California. So that's why we provide that information to them, because they're required in statute to value it in that manner, and so we put that number out for them annually. And it's reported through the United States Department of Agricultural, their National Agricultural Statistics Survey land values for 2022. And that's where that number comes from.
Oh, okay. So we get the numbers from US Ag?
Mm-hmm.
And then we publish them and make them available for assessors throughout the state?
Right, because they need them to do those annual valuations.
Yeah, okay.
Yeah.
So it's just a service of providing information that's that's easier available through an LTA versus them having to do their own research?
Yes, and it also helps to keep it consistent, so that everybody has that same place to
Yes.
go and is getting it directly from us as well, so.
Yeah, that's great. Thank you.
Excellent job.
Mr. Young? Mr. Young, did you have anything you wanted to say?
No, I
No?
just wanted, if you're looking for background on this urban ag land, it's an inducement for people that own property in an urban environment. Usually, urban environment land it's a little bit more valuable than cropland. So as an inducement to restricting your use to only growing basically agricultural products in an urban environment, they give you a preferential assessment. So usually it's lower than if it were assessed as urban land.
Okay.
So that's why
So
it's there.
this LTA is narrow then, just for urban ag land?
Correct.
It's
Yeah.
forcibly restricted.
Yeah.
Yes.
It has to be
I was trying to
restricted.
figure out
enough.
what that meant.
Yeah.
Yeah.
Yeah,
Okay, thank you.
of course, anytime.
Mr. Schaefer, did you have a question?
Yes, Mr. Young, automobiles are all assessed by the Department of Motor Vehicles, and the value of our car on their records goes down every year, and it's done automatically, and, and it works. Getting to the yachts, that is our responsibility. Can I assume that our assessors are just as automatic as the DMV and ratcheting down the value of the yachts every year as they age, or maybe I should check up with my assessor and see how he's doing. We have a lot of yachts, in the Water City. I'm sure he's had some inquiries from people who don't think it's ratcheting down. The most important day in a yacht owner's life is when he buys a yacht and then when he sells the yacht.
Right.
They do lose their luster and their value rapidly, and I want to be sure that they don't have to go begging for this. I want to see that the assessors are leading the parade.
The assessor is charged annually to assess these vessels at their fair market value. So on average, usually the physical depreciation carries the day, and it's usually worth a little less because it's not getting any younger. But in certain instances, like last year, we saw it with used cars, the demand for used cars because the supply chain was pretty high, and there were folks that were basically able to sell their used car for about what they paid for, and sometimes maybe a little bit more. So the assessor's charge is to find its fair market value on the lien date for these vessels.
Yeah, I realize it's been different recently for cars.
Yeah, so,
Okay, well, at least they're aware of it. Thank you.
okay, you're welcome. No,
There's
if
no
there,
further questions for me.
No. Oh, I'm sorry. Yeah.
Just one quick, now that you mentioned on the assessed values, do we actually handle that, like on a probate, for example, case?
We
You don't do property, right?
no, we
Or-
do not value the property. Most of the property is valued at the county assessor's
county,
level. Yeah. Except for, of course, the state assessed for the public utilities. That's the only exception.
Thank you.
If there's nothing else, I will move on to the very last item for.
Yes, please.
For the Deputy Director's report. That will be by Ms. Cruz, and she will give you an update on the State Assessed Properties Division.
Good afternoon, Chair Cohen and honorable members. My name is Michelle Cruz, manager of the State Assessed Property Division. Today, I will provide information on the status of ongoing work in our division. SAPD staff continue to work on this year's petition workload. Staff are currently working on completing our written responses to each of the petitions for unitary reassessment. Some petitioners have requested an appeals conference as part of their petition filing. SAPD staff are also preparing for those appeals conferences and look forward to attempting to resolve petition issues with petitioner representatives during the appeals conferences. The first of this year's petitions to come before the board will be presented at the October board meeting. We also anticipate petition matters coming before the board at the November and December board meeting as well. That concludes my report. I'm available to answer any questions.
Mr. Vasquez has one?
Is this this is your first time before, isn't it?
No.
Oh, I guess I didn't remember last time. Well, anyways, I was going to welcome you, so go ahead. That was
Always
great.
been in an online setting. Yeah.
Yeah.
Do you have a question?
If I could.
Yes, please.
Yeah, thank you for your presentation. And in terms of petitions, what sort of petitions are coming forward?
I would say there are a broad range of petitions throughout our different industries, such as gas and electric.
Okay.
We have some telephone. I believe we have a couple pipelines and a power plant.
Okay.
We have a total, I believe, of 19 or 20 this year.
Yeah, okay. Are those appeals?
Yes.
Okay, all right. So a mixture, coming from different industries.
Yes.
All right, thank you, appreciate it.
All right, thank you for the presentation.
Of course.
Appreciate it. Mr. Getty, let's take public comment.
AT&T moderator, please let us know if there's anyone on the line who'd like to make a public comment regarding this matter.
If you'd like to make a public comment, you may press 1 and 0 at this time.
I'm so low all of a sudden.
And I'm seeing no one in queue.
Thank you. Let's call the next item.
Our next item on the agenda is K5A, Legislative Research and Statistics Division Chief Report, Legislative Issues, Update on Administrative and Program-Related Legislative Bills Impacting the Board of Equalization. This item will be presented by Mr. Weatherby.
So good afternoon, Chair Cohen, honorable members of the board. This is Dustin Weatherby. I'm Chief of the Legislative Research and Statistics Division. So attached to the PAN is a summary of any legislation that is affecting the Board of Equalization that is on the governor's desk. So the last day for the governor to act on any bills for the 2021-2022 legislative session is this upcoming Friday, September 30th. So the first bill I want to highlight is BOE sponsor SB 440 by Senator Dodd. SB 440 was signed by the governor on September 13th, and it authorizes the BOE to provide deadline extensions and penalty and interest relief to taxpayers under the alcoholic beverage tax law during a governor-proclaimed state of emergency. This bill mirrors similar changes made by CDTFA to other special tax and fee programs, ensuring equity and administrative efficiency in providing taxpayer assistance during these circumstances. The second bill is Senate Bill 1494 by the Senate Governance and Finance Committee, which also contains one of the board-sponsored legislative proposals to amend Revenue and Taxation Code Section 97.68 relating to a sales tax augmentation fund, just to correct references from BOE to CDTFA. That bill was also signed by the governor on September 19th. And the final board-sponsored proposal, SB 1496, also authored by the Senate Governance and Finance Committee, amends Revenue and Taxation Code Section 32471.5, which would extend the sunset date for the offer and compromise program under the alcoholic beverage tax law for an additional 5 years until January 1st, 2028. That bill was also signed by the governor on September 22nd. Then AB 1206 by Assemblymember Bennett, which would require that a rental unit continue to be treated as occupied by a lower income household when the income of those occupants increases up to 140% of the area's median income if the owner of that property is a community land trust whose land is leased to low-income households for the fiscal years 2022-23 through 2027-28. So the board voted at the February board meeting to support AB 1206, and that bill is currently awaiting action by the governor. The next bill is Senate Bill 989 by Senator Hertzberg, which allows certain taxpayers to defer payment of local property taxes with penalty and interest relief if they have claimed a Proposition 19 property tax relief with the county assessor and have requested deferment with the assessor within 1 calendar year, but before January 1st, 2024, of receiving the first property tax bill for the first tax bill for that property. The bill's provisions only apply to LA County right now, but a county may opt into the bill's provisions upon consultation with local officials and a resolution by the Board of Supervisors. So that bill is currently also awaiting action by the governor. And the final bill I'm going to highlight is Senate Bill 518 by Senator Laird, which would require the BOE upon request to provide confidential taxpayer information on the wine grower tax return and schedule for returns filed on and after January 1st, 2023, unless that taxpayer is a natural person. The bill's provisions require returns to include an opt-out box for taxpayers who do not wish to have their confidential information shared publicly, and that bill is also awaiting action by the governor. So that's going to conclude my presentation on this item, and I'm available to answer any questions. Thank you.
Very much. Mr. Vasquez has a question for you. Sir.
Thank you for those updates. And I just had a quick question, and it's partially related to the SB 1494 you mentioned. which I understand that the existing property tax law requires that certain revenues not allocated to the county, cities, and special districts are to be transferred to this educational revenue augmentation fund in that county for school districts, community college districts, and other county offices of education. So if the county had a significant property tax revenue losses, is the loss evenly split between the educational augmentation fund and the county, cities, and special districts?
Thank you for that question. I'm not exactly sure on the specifics. This particular proposal only corrects a reference from BOE to CDTFA. So how the mechanics of the other parts of the provision work, I'm not certain on, but I can check on that for you.
Appreciate it.
But I believe it's a sales tax fund, so that would be administered by the CDTFA.
By the CDT, okay.
Yeah.
That's it, thank you.
Thank you.
Let's take public comment.
Yep. AT&T moderator, can you please let us know if there's anyone on the line who'd like to make a public comment regarding this matter?
If you'd like to make a public comment, you may press 1 and 0 at this time. And I'm seeing no one in queue.
Thank you. Mr. Keddy, please call the next item.
The next item on the agenda is M1, Public Policy Hearings, Proposition 19 Implementation. There are no planned staff reports or external speakers for this agenda item for this month's meeting. However, persons who wish to address the board on this topic as a public comment may do so. Call the moderator?
Yes, please call the
AT&T
moderator.
moderator? Yeah. Please let us know, sir, if there is anyone on the line who'd like to make a public comment regarding this matter.
Once again, if you would like to make a public comment, you may press 1 and 0. And I'm seeing no comments.
Great, thank you
Thank
very
you.
much.
The next item on the agenda is M2A, Public Policy Hearings, Impact of Public Calamities on Property Tax Administration, County Boards of Equalization, Assessment Appeals Boards, and Remote Hearings. There are no planned staff reports or external speakers for this agenda item for this month's meeting. However, persons who wish to address the board on this topic may do so as a public comment. AT&T moderator, please let us know if there's anyone on the line who would like to make a public comment regarding this matter.
Once again, if you'd like to make a public comment, you may press 1 and 0. And I'm seeing no one in queue.
Thank you. The
Next
next
item.
item on the agenda is N, public comments on matters not on the agenda. Persons who wish to address the Board of Equalization regarding items not on the agenda may do so under this item on the agenda. Please note that the board cannot take any action on the items on the agenda. However, the board can schedule issues raised by the public for consideration at future meetings. I do have a public comment to read into this, but we'll go to the moderator first.
Okay.
AT&T moderator, please let us know if there's anyone on the line who would like to make a public comment at this time.
If you'd like to make a public comment at this time, you may press 1 and 0. And I'm seeing none in queue.
Thank you. The public comment was received by a Michael Pisano. It was received via email to our meeting info mailbox. Hello, BOE. I talked with Michael from the BOE on May 12th, 2022 at 916-274-3361, and Michael was going to get back to me with answers to my questions. As of today, I have not heard back from Michael. I re-emailed the BOE on September 6, 2022, to change the method of calculations to fairly assess my 1968 mobile home. I have been requested to contact the BOE by the Santa Cruz County Assessor's Office regarding Tax Section 5801, Section 61, and Section 62.1, per my notice of supplemental assessment dated October 14th, 2021. Also, Tax Sections 62, 63, and 63.1. My county supervisor also asked me to contact the BOE directly, as did Congressman Jimmy Panetta's support staff and Senator John Laird's support staff. I bought a membership share in a mobile home park on February 1st, 2021 for $48,000 and pay a pass-through estimated property tax on the full purchase price of $235,000 on my 1968 mobile home in my space rent invoice from the Park Homeowners Association for $218.56 a month. I also pay HCD fees and have not voluntarily gone on the tax rolls per Section 5801. I understand the nonprofit bought the park that I live in, and this is a pass-through tax for the nonprofit. I want to pay my fair share, but only on the $48,000 for the stock certificate membership. But the calculation method is incorrect. I think this would help many seniors with fixed incomes afford to live where they are and not avoid those large outside corporations that buy up mobile home parks and raise space rents to force out residents. Please encourage mobile home co-ops by alleviating this large tax inequity. The only vehicle that may have caused me to pay property tax, which the previous owner did not pay property tax, was the membership share of $48,000. So, if this is the only vehicle, the $48,000, then it is logical to only pay property tax on the $48,000 and not on the full purchase price of $235,000. If I did not buy a membership, then I would only pay HCD fees since my mobile home was manufactured in 1968. It seems against the law listed to assess the full $235,000. 1. Why is the property tax assessment not only on my $48,000 share per Section 61, a portion thereof? A, this seems usually on tax on the full purchase price of $235,000. This seems unfair and not equitable based on the past owners only paying HCD fees. 2, if I own a share of real property, why do I also pay space rent? 3, I pay both property tax and HCD fees, and I never voluntarily went on the tax rolls. A, the previous owners of my unit did not pay property tax and only paid HCD fees. 4, what happens, God forbid, if the management of the park does not pay the property tax? 5, why would I not be assessed directly and given my own APN number? 6, what is an escape assessment per Section 62.1? 7, I cannot find a tax law to support paying both HCD and property tax on a 1968 mobile home. It only shows either or and not both. Thank you for your time. Michael Pisano.
Could you tell me, where does Mr. Pisano live, or which BOE district he's in?
I'm not sure, but it appears that he was from Santa Cruz. He had gone to the Santa Cruz assessor, I believe. Let me go back to the beginning.
Mr. Vagnini,
The
okay.
Santa Cruz County Assessor's Office.
Right, thank you, I appreciate that. Did this person leave contact information?
He did, yes.
Okay,
His
we'll follow up.
telephone
Thank
number
you.
and email address.
Are there any other?
No
public
other
comment?
written comments.
All right, let's go to the phone line.
We did already prior, the way that we did is prior.
Okay.
Mhm.
Well, thank you very much.
Yes.
We will receive that public comment. And is there anything else on the agenda for us?
No,
to take
our
care of?
last item is the closing remarks for the day.
All right. I don't have any closing remarks, colleagues, do you? Do you guys have any? No? Okay. So we will recess the board meeting until tomorrow, Wednesday, September 28th, 10 a.m. Thank you very much for your service.